define it in very narrow terms, right? So the idea is very simple in the sense that you approach the court with an issue of climate change. But that's too simplistic a definition. I think a broader definition is to think of climate litigation as one of the pegs in the wheel of a larger legal strategy of climate action. So you have excessive reliance on courts now to activate climate action through the law. So if you look at, say, the DG Khan case in Pakistan, it was actually a mere case of administrative law, wherein an environmental clearance was not being abided by for a cement plant. But then the judge took it upon himself to extend that very basic environmental question into the climate context. So it's, in some sense, not only is it sort of looking at the role of courts as engendering progressive climate action in the law, but it's also becoming an effective tool for filling the gap where the law is absent. So in some, I mean, one way to look at it is the courts are a kind of a gap filler when it comes to the climate change question. But the challenge with climate change litigation is, despite it being successful in the global north and in countries in the global south, it still plagues the age-old question of, you know, like this argument that the socio-legal scholar made of hollow hope, right? Where you had these huge progressive judgments from the courts, but enforcement was nothing. So there was a recent piece in The Guardian as well, sorry, in Bloomberg, where they looked at enforcement of the Shell case, and it's been mighty difficult. So how does one then define climate change litigation? I would like to kind of, veer towards a more expansive definition. I think it's about the role of courts and the role of different actors approaching the courts on very pertinent issues of climate change, whether it's holding companies accountable in trying to push the state from its lethargy into action. But it also is becoming a space to look at climate adaptation. Another element which is important to think about when you're thinking about climate litigation is jurisdiction, because historically all environmental issues are multi-jurisdictional and trans-jurisdictional. So it's very important to understand climate litigation as a trans-jurisdictional effort. And I think the Bhopal gas case in India is an interesting example of where we've tried to look at that in the environmental context. But in the climate context and climate litigation context, we are yet to see such a multi-jurisdictional case, right? So in the recent German Constitutional Court judgment, where it looked at the rights of future generations, it actually had youth from Bangladesh who were petitioners as well. But the court said that they didn't have standing. So we'll have to look at this question of what are the possibilities of the courts and what are the limitations, and whether regional courts will start to play a more important role, at least in the Latin American and African context. In the South Asian context, I feel climate litigation is, not just a jurisdictional question, it's also a geographical question. So ecologies sort of become the jurisdictions, whether we look at forests or deltaic plains or all of it. Interestingly, that's not emerged yet. Maybe the Amazon case in Brazil is one such example where this has happened, but also again trans-jurisdictional because it borders 3 countries. So yeah, I can keep going on, but just to conclude that climate litigation is not just about going to court, it's about multiple things. It's also about legal evidence. What kind of evidence can we use to make attribution claims?